Again, it just takes one. So the question is, how much impact will these closing arguments have on this jury that's been deliberating 6 hours and 36 minutes? How much of an impact does it ultimately have here? Let's get an answer. Bring in my think tank tonight in Orlando. Criminal defense attorney Shannon Ligon joins us in studio. Criminal defense investigator Charles Middlestat, entertainment law and criminal defense attorney Tiffany Porter, and criminal defense attorney Michael Bixon. Great crew here. I'm going to start down in Orlando. Shannon, you know this Central Florida jury pool. So how much of an impact do these closing arguments have for a jury who has to decide the ultimate question here in what they're going to recommend?
Well, as you said, we're here in Orlando, Florida, and we have seen our share of dynamic cases. So I thought it was very interesting that on both of the defense and the state in articulating, what they wanted, whether it was a death penalty or the life sentence, they stayed away from Mr. Nelson's commentary, his own commentary while on the stand of asking for the death penalty. But I did find it very great that the defense attorney was very diligent in her job, still going through the mitigating factors. She explained the difference between aggravating and mitigating factors, and like you said, the real tough job that the jurors are going to have to decide whether it's unanimous or not, that he will get life or he'll face the death penalty. So again, it could just take one juror to, again, have some sympathy, and like the defense said, she wants them to use mercy and temper it with justice. So it will be a very interesting decision what these jurors come out with here in Orlando, Florida.
Absolutely, and you talk about sympathy, and this defendant is the least sympathetic defendant I've seen in quite some time in the trials that I've covered through the years. This is a guy who is so unlikable, yet we're at 6 hours and 38 minutes and we have no idea what they're going to say here. So how much of an impact do you think these closing arguments had?
They have a lot of impact. That's your final, that's where you just put everything out, lay everything out for the jurors, and you try to reach them on a human level and talk to them. And no matter what they've heard all day and throughout the trial, you want them to, as a defense attorney, to empathize with you and to believe your story, and you want them to pretty much go with what you are saying, but you also want them to, no matter what they heard and with his confession, you want them to empathize with your client. You want them to be able to empathize.
That is a huge mountain to climb with Scott Nelson. And by the way, as Shannon pointed out yesterday on the witness stand, he did say, "Send me to death row." I mean, which voice is going to be resonating in that jury room tonight? Is it Scott Nelson's voice or the attorney's?
And we all know why he wants it too. He wants that platform to grandstand. We've seen him take the stand over and over, and it has nothing to do with this case. It's all about him. From day one, this case has been about him. That's all he wants, is to be able to get up there and grandstand and get his message out. Honestly, I think the worst punishment they can do to this guy is take that platform away, put him in life so that he doesn't come up every single time his execution is going to come up, and allow him to have that platform. And we know he wants that. There's no question about it at this point. And I think that was probably one of the most convincing arguments I heard from his defense attorney, was to, basically, if you sentence him to life, he doesn't have that ability to do that anymore. I think that was great on her part.
So whose voice are they listening to? Are they debating in there? Is it what the lawyers are saying, or what Scott Nelson himself said? Because he got up on the witness stand 3 times during this trial.
I think it's probably a combination of all, Vinnie. I mean, at the end of the day, I've been part of several death penalty cases in my career. Fortunately, none of my clients have been sentenced to death. But in this particular case, I really think you can take the aggravating circumstances, the mitigating circumstances, you can take the statute, all of the steps necessary to get to that decision, and I think you can throw all that out. At the end of the day, it's a subjective decision based upon how these jurors feel about the death penalty, whether they believe he's mentally ill, and if you look statistically, the death sentence is awarded less and less as a result of a lot of factors.
And in Florida, it used to be really easy in Florida, much more difficult. 13th juror question about the closing arguments, which was more persuasive, prosecution or defense? Let us know.
All right, Mr. Nelson. Good. I'm good, Your Honor.
Do you have any complaints regarding your attorney's performance in representing you at any time?
Well, I'll be quite honest with you, Your Honor. As far as my attorneys go, they have exceeded my illusion of the excellence. I think they've done me justice, sir. I have no complaints about them at all. I think they've done an incredibly good job representing me. No complaints.
Okay.
Past, present, or future, sir.
All right, thank you.
That could be the most shocking moment of this entire trial. Unbelievable. That was earlier today. What you're looking at right now, that's a live shot, or it was over here, I'm sorry, a live shot inside the courtroom right now. That's the courtroom seal. What we understand is that some of the lawyers are now gathering in the courtroom. We don't know why. It could be because at 8 o'clock they have to make some sort of a decision and check in with this jury, or maybe something else is going on. Not quite sure, but we'll let you know as soon as we know. In the meantime, I've got my think tank with me. A little reaction. Scott Nelson loves his attorneys, Charles. How about that?
That's
satisfied.
That's a first for a client who gets convicted, and he proclaims his absolute appreciation and satisfaction with his defense team. That's awesome. I haven't seen that before.
Unbelievable. We're just getting some word from inside the courtroom, by the way, that dinner arrived just a few minutes ago for this jury. So my guess is if you ask them at 8 o'clock if they're going to continue, they're going to at least continue eating their dinner, which is that Italian? Is that what we're hearing? Italian food. Okay. There's some good Italian restaurants down in Orlando. I lived there for a while. All right. Away from that, back to Scott Nelson. That's amazing, right? I mean, the whole trial he's talking about fighting with his own attorneys, telling them that they're doing injustice, demanding that they get a mistrial, everything else. Now he's totally satisfied. Why?
Well, my question would be, what is he going to do on appeal if he tried to appeal? Now, you can't argue ineffective assistance of counsel. At this point, you said you loved your defense attorneys, that they went exceedingly above and beyond.
I think he said past, present, and future.
Oh, yeah.
Shannon, are you shocked?
You know, this case has had so many fireworks. It's hard to be shocked because as a criminal defense attorney, when I saw him get on the stand, admit to the murder, and then additionally get on the stand and ask for the death penalty, I am a little bit perplexed that he is switching sides about complaining about his attorneys to now, again, saying that, you know, he's overzealous in their representation. So again, there's more fireworks this case. It again goes to some of his mental health issues that have been compelling in this case. So I'm interested to see how the jurors are going to weigh all of this, you know, especially hearing that he feels like their attorneys did a great job, and here the defense counsel is trying to argue that his life should be spared and get life when he just got off the stand and asked for the death penalty. So again, more fireworks, and it's going to be a big decision that the jurors here are going to have to unanimously decide on.
Absolutely. And yesterday he was complaining because his attorneys didn't ask him those 2 questions that he just had to answer. It was what the case was all about. Without those 2 questions and the answers, there was no point to any of this. And it happened. All right, folks. What are we going to do here? Okay. They're getting ready to get together inside the courtroom. We'll take you inside there as soon as they get there. In the meantime, we've got a 13th juror question for you. Who had a more persuasive closing argument, the prosecution or the defense? Let us know. Prosecution, defense, go to Facebook. Judge is on the bench. We're going to go in. All right, we're going to go to break. We'll listen to the judge when we come back.
I'm Julie Grant. As a lawyer, I'm an officer of the court. As a prosecutor, I represented the people. Now, on Court TV, I represent you.
You have to look at everything in this case.
Because it's my job to bring you the whole truth and nothing but the truth.
The all-new Court TV, your front row seat to justice.
All right, we've got some breaking news inside the courtroom. The jury has a note. Let's listen in.
Ms. Burke, is the state acknowledge the jury? Ms. Emmons, defense?
Yes, sir.
Mr. Nelson?
Yes, Your Honor.
All right, members of the jury, I have received your note. I'm going to read it just to make sure that I'm reading it correctly, and then I'll respond. I read this as follows. Please provide a copy of the DSM-5. If I have not read that correctly, please raise your hand. Seeing no hands. Members of the jury, I'm not able to answer this question because it calls for information that is not in evidence. Your decision must be based only on the evidence presented in the trial and the law that I have given you. Please return to the jury room to continue your deliberations. Thank you. All right, the food was actually just delivered, so the jurors have not eaten, but it was just delivered right probably about the same time as the question came out. So because they haven't even got their food now, when we go into recess, it will be until the earlier of a question or verdict or 9 p.m. I give them an hour, and then we will touch base with them and see where they are. Anything else from the state before we go into recess? Defense? Mr. Nelson? No, sir. All right, we'll be in recess until the earlier of a question or verdict or 9 p.m.
All right, so that's the latest from inside the courtroom. The jury wanted a copy of the DSM-5, which deals with some of the potential mental issues that Scott Nelson is dealing with, but it's not in evidence, so they don't get a copy of it. The bottom line is that's probably good for the defense because they are, in some level, considering the mental state of Scott Nelson. So that's pretty significant, pretty important. What you also heard is that dinner was just delivered, so they'll be eating now while they deliberate in that room. Also, they're going to check back in at 9 o'clock. Let's check in with Julie Janae, Court TV crime and justice reporter, who is now outside the courtroom, outside the courthouse in Orlando. Julia, this is a pretty big development, a note wanting the DSM-5. So that seemingly would be helpful to the defense because those are the issues that they brought up for the most part.
Absolutely. This was a big, thick manual that Chelsea Simmons read from when she was doing her cross-examination of Gregory Pritchard, who was the state's psychologist expert, and she had him looking through it as well. So these jurors saw that book. They saw her going through it and calling from it and asking him to look on this page and to ask if the mental health disorders that they were discussing were listed and how were they listed. So it can be frustrating for a jury to know that there was evidence that they saw happening during the trial or that they saw being talked about, but that they don't have it physically in the jury room. So it's something that they're not going to get. So who knows what they'll ask for next, if they'll want to know more about that testimony where they discuss the DSM-5. But it kind of rings true to what they asked for in the previous trial during the guilt phase. They asked for things that were talked about during trial, like the letters that Scott Nelson wrote to police, but those were never entered into evidence. So even though they saw them, they saw a witness holding it up, they weren't privy to that information back in the jury room. So this is just a very astute jury. They really are careful and going through everything, and when they don't have something, they have no qualms about asking for it.
Absolutely. Now, the judge said he's going to check back in at 9 o'clock with the jury, but is there any time limit tonight? And I'm asking because folks at home have been watching all night. We're here. Is there a time where the judge has to have everyone leave and send the jury not home but to the hotel because they're sequestered tonight, or can they stay until whenever?
Vinnie, our understanding from this court is that the rules require simply that they check in with this jury, that they not limit them in any way, that they continue to ask them if they want to continue deliberating. So it really falls on this jury. We know that we've been at this courthouse until 10 o'clock just doing jury selection, and many hours after closing hours working out jury instructions. So we know Judge Keith White does not mind burning the midnight oil in order for justice to continue here in the courthouse. And there's an entrance that I talked to the security guard. They said it's open 24/7 for qualified people to go through. So this courthouse can certainly continue to house them if they want to deliberate on into the evening. But it will be, our understanding is, it will be up to these jurors whether they want to keep going or if they want to retire for the night.
Right, and we're getting close to now 7 hours of deliberations today, and if they do go to 10 o'clock, 11 o'clock tonight, and they don't reach a verdict, they've got to call the hotel for one of those late check-ins, which potentially could happen. But again, we will bring it to you, and of course, we'll be on the air here at Court TV whenever this jury comes back with a verdict. We're not leaving until the jury leaves, and when we stay after the jury's here. Let me check back in with my think tank on what we just found out from inside that courtroom. The DSM-5. I mean, if I'm the defense, I'm thinking that's pretty good for me.
I think that's great for the defense. I mean, the defense wants the jury to really sit down and consider everything, especially his mental health, everything that he's gone through with his family and how that might have affected him. These are things that are going to go towards the mitigating factors, and this is what they want to hear. The fact that it's actually not in evidence, I think, could hurt them, because I think it would be good for them to have it, for them to read through and to compare against what they've seen so far in the trial. If I was the prosecutor right now, I'd be sweating a little bit when I hear a note like that.
Yeah, I don't think this is necessarily good for the prosecution, but the bottom line is they're still going through the deliberating process, and as Julia Janae told us on that verdict form, there's like more than 50 mitigating factors listed, so I could see somewhere in those 50, the DSM-5 is going to be very relevant.
Right. But unfortunately, they won't have access to that.
Yeah, they always want something that they can't get, by the way.
Honestly, Vinnie, I don't know that that's necessarily a bad thing. They're just going to have to rely on the testimony of the two experts, and the fact that they are...
And they can always get a read back, too, if they want.
Absolutely. The fact that they are focused on this issue, and that they've had some real-life examples of his behavior in court in the form of him his change in behavior, his attitudinal change towards his defense team. They're seeing there's some issues here. There are some clear mental health issues, and it all plays right into that. I don't know that it'd be a good idea for them to be playing sort of immature psychologists by trying to read into symptomatic issues, having access to that DSM-5.
But that's what people do, right? On WebMD, that's what we all do. We all diagnose ourselves, so they might try to do that themselves as well. So, we're in hour 7 now. At what point do we think this is a long deliberation for a penalty phase?
I don't know if there could be enough time, honest. I mean, they're weighing a man's life in their hands. It doesn't get any more serious. I mean, even if you were just considering something like life, even that, but literally executing this man, I mean, you could take potentially, days, even a week, more. I mean, what time?
If you're having a debate, and I'm not sure if they're having a debate yet because they've got to go through all these and answer all these different questions, but if they're having a debate, at what point does this jury say, oh, wait a minute, why are we debating? If one of us doesn't want to do it, we don't do it, right? So at what point in going through those questions do you think the debate ends and they realize, hey, it is what it is?
Well, it can go on and on and on. And from a defense standpoint, we love that. We want them to keep deliberating. That means that they are actually taking the time to go through each mitigating circumstance and all the mitigating factors and really think about them, not just from what they heard, but actually thinking about them and how it applies to Mr. Nelson. At the end of the day, we love that. I love that they're still there.
Here's my point where we are now, though, because in the guilt phase, it's got to be unanimous one way or the other way. But here, it's only got to be unanimous one way. And if it's not, then it's the other way, right? So, Shannon, at what point would you expect this jury to maybe have the light bulb moment if in fact they're debating this and there's one or more that are saying life, that they say, well, it is what it is. All 12 of us aren't agreeing, and according to the verdict form here, if we don't agree, then it's life.
Yeah, I think it's going to come down to the characteristics of the jurors and their individual leadership, because if that light bulb comes off and they say, hey, we're going to have to agree to disagree, then their vote is going to have to go one way to spare this man's life and go for the life sentence. So again, it's going to be a lot of personality, a lot of people to really have initiative to speak up about what their personal beliefs are about this opinion, about this decision. So, I'm hoping that they, this is a chance that would matter most for them to use their voice. So it will come down to, each individual's choice on, how they feel that they should spare Mr. Nelson's life or not.
Tiffany, how about sequestration? This jury has not been sequestered through this trial. There was the talk of it during the guilt deliberations, but it was done in 4 hours, so they didn't have to spend a night. Do you think that's at all going to play into how late they go and how they come to that decision that, hey, we can't agree?
It may. I hope that it doesn't. I hope that the time, that they use the time to really go through everything. Because again, as Michael said, this is someone's life. And they have to make the decision whether they're going to be sequestered or not, and take the time to go through everything. I don't think that that's going to come into play here. It seems if they've already been deliberating for 7 hours, that they are really going through everything piece by piece.
Yeah. Charles, do you think sequestration will play any role in them perhaps saying, hey, all right, we tried and we don't all agree, so it's life?
I don't know. I agree that it really comes down to personalities, and it comes down to the loudest voice in the room, the power of persuasion, trying to sway, when you see often after the fact, when you talk to a foreperson and when you have a chance to interview jurors, you learn so much about what happened behind closed doors, and I think this is one of these cases. I think this is a supremely difficult, probably the most difficult thing for any group of citizens to do, is to make a decision about taking another human life. And so it seems like they're extremely diligent about it, but I don't know that sequestration plays a role. They seem to be taking their responsibilities very, very seriously.
Yeah, and think about how it all starts, right? You just get a little notice in the mail, right? Oh, you got to go down to the courthouse on this date. And now these 12 people are deciding whether or not to recommend life or death for Scott Nelson. All right, we're live in Orlando. We will stay on it, folks. We'll be here as long as it takes. Our 13th juror question: who had a more persuasive closing argument? Was it the prosecution or defense? Go to Vinnie Politan Court TV on Facebook or Court TV on Facebook. Put your vote in. Leave a comment. Let me know what you think about what's happening out there in Orlando tonight. We're on a verdict watch. Verdict can happen at any moment, and when it does, you will see it live right here on Court TV. That's what we do, folks. Gavel-to-gavel coverage of the nation's biggest and most compelling trials. Right now, it's more than 7 hours, but earlier today, closing arguments for this jury from the prosecution and defense. Different styles, but both very effective. Let's take a look.
On September 27th of 2017, Jennifer Fulford became a means to an end. Jennifer Fulford is dead because the defendant wanted an opportunity to come into a public forum, take a witness stand, not once, but twice, and tell the world about the people and the entities that he erroneously believes have wronged him. The defendant is a narcissist. It is all about him. It is always about him. His intent was murder. Because his cold, calculated, and premeditated plan, he couldn't get to his end game of being able to take that witness stand and being able to rail against the world and getting the attention that he wanted to get from the crime that he committed unless he went big. 22 minutes. 22 minutes he's in that house, and she's left to wonder, is this just a robbery? Am I going to be raped? Am I going to be killed? 16 minutes in the back of the car before he gets to the ATM. 16 minutes under a blanket, not knowing what is happening, where she is going, what's going to happen to her. 1 hour and 24 minutes later is when he gets to the murder site. By the time he got there, she had been in the back of that car for 1 hour and 40 minutes. The person who has kidnapped you doesn't bring you to an open field in the middle of nowhere to do anything other than murder you. The word mercy, forgiveness, compassion, leniency, pity. These are words that should never be associated with this man. Find that the death penalty is the only appropriate sentence for the murder of Jennifer Fulford.
We've heard that Mr. Nelson has been diagnosed with several mental disorders. Mental illness including post-traumatic stress disorder, depression, bipolar disorder, cognitive deficits, problems with executive functioning, and possible autism spectrum disorder. And you've heard that all of these problems affect his ability to make sound decisions, to control his impulse. The testimony you heard shows that. Mr. Nelson's behavior during this trial shows that. The murder was motivated, at least in part, by a desire to obtain money, property, or other financial gain. He did not gain any of those things due to the murder itself. And so you have to apply the evidence that you have appropriately. He testified in this phase of the trial that he's a homicidal maniac. But there's no evidence of that. Compounding his issues, Mr. Nelson was institutionalized for 25 years. He suffered emotional and physical trauma while in prison. He told you about the lights being on for days at a time, the heat being so hot it was unbearable, being cold in the winter, being in constant fear of harm from cellmates, left in a cell with a maniac. There were times where he was left alone in a cell. That was psychologically damaging. Your social skills become much more narrow and in some cases can be maladaptive, meaning someone who already doesn't have coping mechanisms from childhood problems is put in prison where they need their coping mechanisms to deal with the conditions surrounding them. This case, what we presented, has been an onslaught of compounding factors. The foundation of his developmental upbringing put him in a place where he's already depressed and exposed to traumatic incidents leading to symptoms of PTSD. Then he has no therapy or counseling. He has head injuries and medical issues leading to frontal lobe damage. All of these place him in a more vulnerable position to where his adaptation to life and institutionalization is even worse. Now this is important because we do not execute the mentally ill, especially those who were likely made worse by their years in prison at the hands of the government.
Closing arguments today, and now the jury has been out deliberating 7 hours and 15 minutes. This is the way it works. When you're on a verdict watch, you do not know when that verdict is coming back. But when it does, you will see it right here on closing arguments if it happens tonight, folks. We're going to stay as long as the jury stays. Now, the latest we've heard from inside the courtroom is that the judge will check back in at the top of the hour. In the interim, we know they're eating some Italian food right now as they continue their deliberations. That's a live look at the courtroom seal. And you can see it right there. That's the courtroom. No one's in there. No one is doing anything. If they were, you would be watching it right now. I've got my think tank back with me. The closing arguments, they completely different styles, right? And the one thing we heard from Julie Janae, who was inside the courtroom, is that they were a little bit more engaged with the prosecution, and I think that was a stylistic thing in the way Kelly Hicks is able to get the attention of this jury versus the defense. But the defense really laid out a roadmap. I mean, there's so many different ways for them to come back with a life sentence. I mean, there are a lot of hurdles for the prosecution. So do you think we should read anything into how the jury reacted to those closing arguments today? Michael, the fact that they were kind of like this.
Absolutely.
During the prosecution closing argument.
I was watching her give it, and it was, you saw her maintain eye contact with the jurors and engage them. And the way that she spoke, it captivated. I mean, it was a totally different style than when you saw the defense get up there. You saw her reading a little bit more from her notes. I think her argument was good. I just don't think it was presented in the same sort of captivating manner that was given by the state. And I think that does matter in the end because, look, if you have 10 aggravating factors and 50 mitigating factors. In the end, it's how much weight you put behind each factor. I think that's what matters even more. And so if they're being even more captivated by the state, and even if they have less, let's say, aggravating than mitigating factors, it goes a long way for them.
Yeah, and in this balancing test that they have to do, it's not the number of factors on each side, but the weight that they give to them. Shannon Lagan joins us in Orlando. Shannon, from your perspective, what are the factors that this jury you think is going to put the most weight on either side? Is it going to be about his childhood? Is it going to be about his time in prison? Or is it going to be about the way that Jennifer Fulford suffered in those last 2 minutes of her life, covered in duct tape, being stabbed 7 times by this man?
They're going to have to weigh it all. They're going to have to weigh the commentary that the prosecution put on and the evidence, in addition to everything that the defense has laid out. I think she did a very good job outlaying not only his historical background with his family, his father, his issues with his brother, to kind of shed light on how Mr. Nelson got to be who he is, in addition to the 25 years he served in prison. Those are, extreme factors that they should consider in their analysis on whether or not he needs to be found with life in sentence or get the death penalty. So I think the defense counsel did a very good job outlining his past, his narcissistic tendencies, his mental health, his abuse, to really humanize him. And that was the job she was supposed to do, especially in the event of any appealable issues. So, the jurors have a very tough job. And in my opinion, I feel like, they have to choose between the lesser of two evils. So, I'm hopeful that, they'll look at all the factors that the defense did a good job outlaying, but, juxtaposed with, we've lost, this woman has lost her life. So, they're going to have to outweigh,
it's
the
tough.
sensitivity and the mercy that they want to have on Mr. Nelson's life.
What we're really talking about here is kind of pitting who he is, right? He's a disturbed individual that clearly has some issues versus what he did. And what he did, Charles, the way she died, and his own words in one of his statements to police that this jury heard, is that he said she knew she was going to die. And then we heard the description of what happens to you when you're wrapped in duct tape, those last 2 minutes, how difficult they were for her. That's, to me, that's one of the most difficult factors would be for me to get over as a juror.
I think the very nature of this crime and how horrific it is, when you look at that, I mean, you can't diminish that in any way. But I think for the jury, in terms of, again, taking a life, if you look at it in the context, is he a serial killer? Are there multiple deaths? I don't know that it rises to that level.
There was a juror that spoke those exact words. That it was a juror that got kicked off, 218. And he talked about how the fact if there were multiple victims, but I couldn't give this guy death.
Right. This guy's clearly a broken human being, right? If you look at his history, he's a career criminal who reoffends almost the moment that he's out of custody. He's exhibited all sorts of mental health issues. We've had an expert testify about his mental health issues and challenges. His own behavior throughout this trial has exhibited and demonstrated that. And so I think that's why there's no surprise that this jury is almost singularly focused on the fact that they have to decide whether he is mentally ill or not. And if they've determined that he is, I don't think they're going to award the death penalty in this case, as they shouldn't.
Our 13th juror question about those closing arguments. Who had a more persuasive argument? Was it the prosecution or defense? We post it on our Facebook pages every day. You can go to Vinnie Politan Court TV or just to Court TV. Court TV has returned to television,
bringing you the cases that change our world.
My client is on trial here for his life.
With live gavel-to-gavel trial coverage from across America.
You'll be there for every compelling moment.
Did you lie to the detective?
Couldn't keep my life straight.
as history unfolds.
Guilty of first-degree murder.
Emotions rise, and justice is served.
The all-new Court TV, your front row seat to justice.
All right, the Verdict Watch continues. We got an eye on the courtroom where nothing is happening right now. That's the courtroom seal. That's a live look. But we are ready for the moment when this jury speaks again. 7 hours, 25 minutes they've been deliberating today. They had closing arguments, jury instructions earlier in the day. Now it's just been them inside that room. Julia Janae, Court TV crime and justice reporter, joins us from outside the courthouse in Orlando. And Julia, not the first late night during the course of this trial.
No, it is not, Vinny. The sun is setting here in Orlando. We've, of course, got our eyes and ears watching everything happening in the courtroom. And it's a courtroom that has seen some late nights, even from this judge. Jury selection that was back a month ago. June 10th is when it started. And there were some nights when they were whittling through those hundreds of jurors that they stayed here past 10 o'clock. So it is not uncommon or unheard of in this courthouse for people to be inside either deliberating or trying to work out a case or carrying on a trial or jury selection, like I said. So it's possible that we could be here much later. It is completely up to these jurors as to how long they want to keep deliberating before they retire to the hotel and become sequestered.
All right, and of course, we will stay on the air as long as this jury is deliberating. So if and when the verdict happens tonight, you will see it on Court TV. Julia, today we finally heard from this jury. Finally, a question tonight.
Right, this is the first note. We had multiple notes during the guilt phase, so this is the first note of the penalty phase, and they are asking for more information. This jury really likes to make sure they have everything that they need when they are in that jury room. It's almost like they go through all of the evidence, everything that's in their notes, and then they ask for anything that they see that's missing. And this is a manual that the defense attorney, Chelsea Simmons, she used when she was cross-examining a state expert, a psychologist who was talking about mental health disorders. So they want that book. They want that manual that lists that information about mental health disorders. Not sure exactly what they want with that book, but they definitely knew what it was, want to look at it themselves, and unfortunately for them, the judge has denied that and let them know it was never entered into evidence, even though it was used as a reference for the attorneys and for the witness on the stand. It was not an exhibit, and they cannot have it back in the jury room. So we have yet to see if they are going to ask for more information about that testimony from those experts, or if they're going to continue on with what they have.
All right, so during the guilt phase, they deliberated 4 hours and 11 minutes, and that was in a situation where the defendant himself got on the witness stand and admitted to the charges in front of the jury live in the courtroom, and it took him 4 hours, 11 minutes to come to a verdict at that point. So 7.5 hours at this point, not totally unexpected with the way this jury has taken their job so seriously. But it's not a simple question. It's not like they just have to say, okay, life or death, right? There's very specific questions this jury has to answer, and there's several of them before they could even get to answering the ultimate question here.
They've got a balancing act to do. They've got to look at both sides, and there are factors that are actually statutory that they have to look through and come to a decision on whether or not those factors apply to this case. They'll look at the aggravators that the state has listed, 7 things that they say are the reason that Scott Nelson deserves death. Some of them are the fact that he did this for financial gain, that he was trying to avoid arrest when he murdered Jennifer Fulford, that what he did was cold and calculated, and that it was heinous or atrocious or cruel. A lot of things that they're working through just on the state side. Then on the defense's side, there are 54 items that the defense has let them know are reasons why their client's life should be spared, mitigating factors. So once they go through those, they then have to do this balance of which ones deserve more weight, which ones are more important. And that can take a lot of time, that can take a lot of paperwork. We know jurors sometimes have a lot of sheets of paper on the wall. They have things that they're looking at and going through together and writing down these votes between themselves. So it takes a lot, and they've got a lot to work through. So probably not that surprising that it is taking them this long. And now they've got food in front of them, so I'm sure that's slowing things down right now.
Just a little bit. They deserve it, though. They've been working hard today. What do we know about this jury? Who are they? What do we know about the makeup of the jury?
Oh, these are 12 jurors, Vinny, and they range in age from the early 20s to 60s from what we can gather. There's also a mix of different backgrounds as far as race. There are 5 black jurors on the jury panel and the rest are Caucasian. We have also a mix of men and women. And there was one juror who was dismissed earlier in the penalty phase, Juror 218, who had said publicly around other jurors that he didn't think he was going to choose the death penalty for this defendant because he said he didn't kill 10 people. And so if that's the case, then I'm not going to choose the death penalty for him. He said that before this case went into deliberations, and that's a big no-no when it comes to jury decorum and rules of the court. So he was questioned, he was dismissed. We learned today that he was replaced by a middle-aged white female juror. She was an alternate. She watched this trial just like all of the other jurors, and then she was named as a qualified juror. And that's the makeup of the ones that we know are in there. We don't know a lot of their background because the juror questionnaires were kept out of the public. They were not shared with the media. So we don't know a lot about what they do for a living or what hangups they may have had during the jury selection process. But I can tell you, just watching them, they all take this very seriously. They are not a very laid-back jury. When they come in, they are definitely about business, and they haven't been very expressive as far as their reactions. They definitely keep what I call a poker face when they are in that jury box, sometimes breaking ranks with that, and you see some tears during particularly emotional times, but for the most part, they keep a very stern look while they are going through this trial.
And how about Scott Nelson? Where is he waiting as all this is taking place? What do they do with the defendant?
He is in a holding cell. He is, of course, not out on bond by any means. He has been in jail since his arrest on October 1st of 2017. That hasn't changed. He is an inmate with the Orange County Department of Corrections, and they bring him into the courtroom whenever anything happens. So if there's a note, if there is a verdict, if there is a time that the judge has said we are going to reconvene to check in with the jury, he has a right to be there, and they do bring him in. He is in shackles. They take that time. Sometimes the process takes about 5 minutes once he is brought into the courtroom to unshackle his arms, unshackle his waist, and then he has shackles on his feet. He keeps those on at all times. He's not wearing any kind of a shock belt that we know, but our understanding is that he is in a holding cell so that they can have easy access to get him in and out of the courtroom when necessary.
And I know Scott Nelson has a little bit of I don't know if it's an obsession, but he's always concerned about eating and food. Early on in this case, when they worked late one night, there wasn't food available for him. Has all that been resolved? So does he get fed in the interim here as well?
Vinny, you're right. He has not mentioned food the way he did almost every day of the guilt phase. He would come in the morning and want to talk to the judge directly about how early he was being woken up before being transported here to the courthouse, and that he wasn't getting his bag lunches at the jail. So he definitely is constantly concerned about his eating habits. But you know, in the guilt phase, or penalty phase rather, we have not heard from him on that issue. He's had other issues. He's had problems with his attorneys. He's had problems with being called a racist and very objectionable to that. But we haven't heard him talk about food. And he, of course, is still getting his meals the same way he would if he were incarcerated. But we haven't heard any complaints from him like we heard in the past.
All right, Julie Janae at the courthouse for us all night tonight. The jury's still deliberating. We will stay on the air until the jury reaches a verdict or goes home tonight. Our 13th juror question about the closing arguments. Which one was more persuasive, the prosecution or defense? Go to our Facebook pages. Let us know. All right, we've got some breaking news out of the courtroom and a note from the jury. Now, what is the nature of the note? We do not know. Sometimes a note is an actual verdict. Sometimes it's not. Sometimes they want something else. Sometimes they need a piece of evidence. Sometimes they have a question about the law. We just don't know, but we've got our camera ready to go as soon as everyone gets inside the courtroom, specifically the judge who's in charge. The lawyers are gathering. Julie Janae, our crime and justice reporter, just made her way up into the courtroom as well. So we'll take you in live as soon as the judge takes the bench. In the meantime, it's about that time, right? It's 8:45 locally down in Orlando. At around 9 o'clock, they were supposed to check in with the jury, but the jury has sent out a note beforehand. So we're standing by waiting to find out what this means. Again, the jury will be sequestered. If they do not reach a verdict tonight, they will not go home. So this note may have something to do with that as well. We just don't know yet what the note is. Got my think tank with me. We've got folks all over the place. Shannon Ligon joins us down in Orlando. Shannon, jury sending out another note. What are your thoughts at this moment?
Well, you know, seeing that the jury deliberated 4 hours on the not guilty verdict, we could have a very, again, detail-oriented jurors asking questions. It could be the verdict. Who knows? Again, you know, we're going to be here on watch. They've been here going on 8 hours, so it's been a long, arduous day for them. So I'm sure they're trying to comb through the questions and making sure that if they've come to a decision, making sure it's a unanimous decision that they all can agree upon. But, you know, again, with these jurors that are combing through evidence, going through statements, you know, they could be asking for evidence to inspect or, you know, wanting clarification on a juror question. So, you know, we'll have to stay locked into the courtroom to see what the jurors are asking of the judge and what the attorneys might have to argue on it.
Yeah, and Shetty, you make a great point that it's been almost 8 hours, which is like a full day's work. So, I mean, it could be, hey, it's the end of the day. We want to get some rest. We want to come back. And if that's the case, then they'll come back tomorrow morning. So what are you thinking right now, Charles? A note coming out after 7 hours and 41 minutes of deliberations here.
Yeah, if they're no closer to any sort of unanimous decision, they may just have decided, like, look, we just ate, let's get some rest, let's reconvene in the morning and get a fresh perspective and start, you know, anew. Or maybe, you know, they've reached some sort of decision, but...
and it's so different here, though, right? Because the decision could be that we all agree that we can't agree, right? And if that's the case, then it's life in prison, right? They don't have to all say life in prison, but they all have to say death. So that's why, for me, it's so difficult to read these moments during the penalty phase versus the guilt phase. Because the guilt phase, hey, everybody's got to agree one way or the other. It's a lot easier to throw in the towel. But do you think they would even throw in the towel and take the room tonight, Michael? Or do you think they would say, well, we did 8 hours and we're not agreeing, so it's life?
The only way that I see it going the other way is if there's someone in there so adamant that they feel like they still have the ability to maybe convince one of the other ones. And there's maybe still some argument left on the table for them to talk about. I mean, look, there's a lot of stuff to go over in this case, a lot of evidence to sort through in terms of the aggravating and mitigating factors. It's possible they just haven't even finished going through them all. You know, I mean, there's a lot. Again, we're weighing a man's life.
14 pages.
That's a lot.
14 pages worth that they have. And I'll hand it to this jury. You know, whatever the decision is, one way or the other, they've put the time in. At this point, they've absolutely put their time in.
Right. And as a defense attorney, I want them to keep talking, keep deliberating, because all you need is that one or two people that are just going to hanker down and say, we do not believe that he deserves a death penalty, and then that's it. That's it. So I want them to continue talking. I want them to keep deliberating, because that means that there's a crack, and that would be good for the defense.
And at this point, I think we'd have to agree that if they all came in there and kind of said, he really doesn't deserve the death penalty, it wouldn't take this long, right? If they all were kind of, take an informal vote or whatever, who's kind of leaning what way. If they were leaning towards life at this point, I think it would be over already. Don't you, Charles?
I don't know, Vinny. I mean,
You're disagreeing with me, Charles.
Wow.
How about that?
Can you imagine?
Yeah.
What, I get the sense that they must be close to something or they wouldn't be burning the midnight oil, right? They would have tapped out and said, we'll go head to the hotel and we'll start again tomorrow because we are so far apart that there's no chance that we're going to come to some sort of agreement tonight. That would be my sense. The fact that they're still working on this would indicate to me that they must be close to some sort of decision, or at least there's still some productive debate going on, some positive, forward movement in their discussions. Otherwise, I think they would have already, like I said, tapped out for the evening. But so who knows? I'm dying to know what this.
I am
what
too.
this
And
note is
again,
all
if
about.
you're just joining us, folks, the breaking news is that we've got another note. There's the judge. He's on the bench. Let's see if he's ready to let us know exactly what's going on. The jury probably not in there yet. He gets on the bench, and then the attorneys are usually in the courtroom before the jury gets in there, and he'll call for the jury. But first, kind of take attendance with everyone that's inside the courtroom and put everything on the record. So let's listen in.